Welcome everyone to the UMaine Artificial Intelligence webinar series. I'm Jessica Miller, Associate Dean for Faculty Affairs and Interdisciplinary Programs in the College of Liberal Arts and Sciences at the University of Maine. I'm sitting in today for Dr. Ali Abedi, Vice President of Research at the University of Maine. I'm very pleased to welcome you wherever you are in the world. We have 300 registrants to this webinar today. So wherever you are, good morning or good evening. Thank you very much for being here. We have a terrific panel today. We have Jim Isaak, past president of IEEE Computer Society and the IEEE Section Chair of New Hampshire. We have Leigh Saufley, Dean of the University of Maine School of Law. And I will begin with Dr. Manuel Woersdoerfer, Assistant Professor of Computing and Information Science at the University of Maine. I would like to say something quickly about the format. Dr. Woersdoerfer will have to leave shortly after his talk, so we're going to take questions, which you can use the Q&A to submit immediately after he finishes. And then we'll have our next two speakers, and we should have some time for questions at the end for those two. Thank you very much for being here. Dr. Woersdoerfer is, as I mentioned, an assistant professor in the School of Computing and Information Science and collaborating assistant professor in the Department of Philosophy at the University of Maine. He is also an associate member of the Climate Change Institute here at UMaine. Before joining the University of Maine, he was an instructor at the Murdo Center for Engineering Professionalism and an associate member of the Climate Science Center at Texas Tech. His current research focuses on three interrelated and interdisciplinary projects: business ethics with a special focus on business and human rights, CSR, and multi-stakeholder governance networks. Also, computer ethics with a special focus on information privacy, big data ethics, and ethical issues of AI and autonomous vehicles. So you can see why he makes a perfect panelist. And finally, environmental ethics with a special focus on climate ethics and justice. His research has been presented at international conferences and has been published in lots of top peer-reviewed journals such as Business and Society Review, European Journal of the History of Economic Thought, and the Journal of Business Ethics. Thank you for being here, Dr. Woersdoerfer.
All right, thank you so much, Jessica. Hello, everybody. Today I would like to take a closer look at the latest developments here in the US concerning big tech and antitrust. As you probably know, there are several ongoing reviews and investigations by the Federal Trade Commission, several state attorneys general, and the House Committee on Antitrust concerning the business practices of Facebook, Google, Amazon, and co. Most importantly, the Department of Justice recently filed a lawsuit against Google, accusing the company of maintaining an illegal monopoly over search and search ads, and another lawsuit against Facebook's powerful position in the social network market due to its acquisition of Instagram and WhatsApp is likely to be filed within the next weeks or so. The question now is, what is the main reason for those investigations and lawsuits, and are those lawsuits justified from a business ethics perspective? Let us begin our analysis by taking a closer look at the economic power of big tech, beginning with the respective market shares of Google, Amazon, Facebook, Apple, and Microsoft. As you can see on this slide, Google has a de facto monopoly in the search engine market with a market share of 93% worldwide. In the browser market, Google and Apple are forming a duopoly with a market share of 66 and 17% respectively. The market for mobile operating systems is also dominated by Google/Android and Apple/iOS. The same is true for the desktop OS market, which is dominated by Microsoft's Windows. And finally, Facebook is by far the most dominant player in the social media market, beside Google's YouTube and Tencent's WeChat, with almost 3 billion active Facebook users, 2 billion WhatsApp users, and more than 1 billion Messenger and Instagram users. In addition, the big 5 tech companies in the US are also among the most profitable companies in the world, as can be seen on this slide, which shows you the latest revenue, operating and net income, total assets, and equity numbers. It is noteworthy that most of those numbers have steadily increased over the last few years, and especially during the coronavirus pandemic, making big tech one of the biggest winners of 2020. Overall, Google, Amazon, Facebook, Apple, and Microsoft, together with their Chinese counterparts, Alibaba and Tencent, rank among the top 10 largest companies in the world by market capitalization. With these enormous profits and revenues come substantial economic powers, which can be used in several ways. One way is to purchase current or future rivals, such as innovative startups, either to get rid of actual or potential competitors, or to acquire their copyrights, patents, and other forms of intellectual property. Notable examples of recent acquisitions in the tech industry include Amazon acquiring Whole Foods, Facebook acquiring Instagram and WhatsApp, Google acquiring Motorola, Waze, Nest, and Fitbit, and Microsoft acquiring Skype, Nokia, LinkedIn, and GitHub. The following two slides give an overview of the conglomerates Facebook and especially Alphabet have built over the last few years. It has already been mentioned that Facebook Inc. includes WhatsApp, Instagram, and Messenger, but it also includes the virtual reality company Oculus. Alphabet, on the other hand, includes not only Android, Gmail, Google Maps, Google Search, and YouTube. It also includes companies such as Calico, a biotech company, Capital G and GV, two venture capital companies, DeepMind, an artificial intelligence company, Nest, a home automation company, Waymo, an autonomous vehicles company, and X, a research and development company famous for its so-called moonshot technologies. What has become clear so far is that the big tech companies are de facto monopolies, or at least oligopolies, in their respective market segment. This means that many IT sectors nowadays are dominated by one or two companies. Hence, we can speak of digital or techno-monopoly capitalism. And one of the main reasons for this trend towards the monopolization of the economy, beside economies of scale and network effects, is the fact that personal data has to be considered the new currency or oil of the 21st century, which further fuels the power of big tech. This means that personal data and information from billions of monthly active users are extremely valuable assets, which can be sold to third parties, for instance, for marketing and advertisement purposes. In addition, these economic powers cannot only be used to purchase startups and other rival companies. They can also be used for lobbying and rent-seeking purposes. Data published by the Google Transparency Project and the Campaign for Accountability show that an increasing number of employees has moved back and forth between Google and various government agencies here in the US, pointing towards what is referred to as the revolving door phenomenon, known from the finance industry. Besides, big tech is also investing considerable amounts of money, for example, to shape legislative decision-making. Data published by the Washington Post show that Google ranks first in terms of annual lobbying spent by company, followed by Amazon, Facebook, Microsoft, Apple, and Uber. It is remarkable that most companies have increased their lobbying expenditures and budgets, and that the number of issues lobbied per year has substantially increased over the last decade. And remarkable is also the relatively high number of meetings representatives of the big tech companies have with high-ranking government officials in the US and in Europe. One of the fiercest and most outspoken critics of the current trend towards the monopolization of the economy is computer scientist Jaron Lanier. And Lanier claims that the information economy that we are currently building doesn't really embrace capitalism, but rather a new form of feudalism. Here, wealth is becoming concentrated around so-called siren servers. And siren servers are companies or platforms that are controlling enormous data centers and are thus able to gather massive amounts of personal data and information at virtually no cost. And the biggest and most famous siren servers obviously belong to Google, Facebook, and co. Lanier not only criticizes those siren server platforms and the concentration of money, wealth, and power in the hands of a few companies, both of which contribute to the formation of a new Gilded Age, he also warns of the societal risk of IT companies becoming too big to fail or system relevant. Now the question is, what could be done about the problem of big tech's increasing socioeconomic influence and power? For this, I would like to turn your attention to ordoliberalism, a business ethical approach dating back to the mid-20th century that has been highly influential in both Germany and Europe as it shaped the socioeconomic system set up after World War II, the so-called social market economy. The ideal ordoliberal state is a strong and independent constitutional state, a state that stands above special interest groups and that serves as a market police, as an ordering power, and as a guardian of the competitive order. This means that the state should ideally be able to fend off particular interests, keep to the principles of neutrality and impartiality, and confine itself to regulatory or ordering policy, one where the government is responsible for setting, preserving, and enforcing the regulatory framework, the so-called rules of the game, instead of influencing or intervening into market processes and the play itself. The underlying ordoliberal ideals are equality before the law, freedom of privileges, and the principle of non-discrimination. To reach those goals, ordoliberalism makes use of a variety of economic and legal tools, including antitrust legislation, cartel, and competition law. One of the main purposes of government is to set up, preserve a highly competitive socioeconomic order and free market economy. Keeping markets open, which includes low market entry and exit barriers, and restricting substantial forms of market powers are crucial in this regard. Hence, the influence of rent-seeking and lobbying or special interest groups, as well as the power of large organizations, have to be restricted. Cartels and trusts need to be monitored and, if necessary, split into several units by an independent agency, the cartel office, and mergers and acquisitions have to be approved by a special commission, the M&A Commission. If the commission is concerned that a specific acquisition might lead to the monopolization of the economy, for instance, when the respective conglomerate surpasses a certain market share threshold, it is permitted to impose special requirements or veto the entire transaction. As mentioned before, ordoliberalism not only had a huge impact on Germany's social market economy, but also on the competition law and economic policy of the European Union. Over the last few years, the European Union has applied some of the ordoliberal principles mentioned before when they investigate the business practices of several tech companies. It all started with Microsoft's Media Player and Internet Explorer in 2004, but the most recent ones include 3 investigations against Google and 1 against Amazon. In 2015, the European Commission accused Google of unfair competition and abuse of market power. The accusation was that Google is using its operating system Android to promote Google's mobile services such as Maps, Search, and YouTube, all of which are pre-installed on most Android devices. In 2016, the Commission broadened its investigation and announced the issue of another statement of objections to Google. This time, the Commission accused the company to have required manufacturers of mobile devices to pre-install Google's Chrome browser, as well as Google Search, and to prevent them from selling devices running on competing operating systems and using alternative applications. The Android probe was settled in 2018 and resulted in a record $5 billion fine for Google. In mid-2016, the Commission opened yet another investigation, this time against Google's shopping service and AdSense. According to the allegations, Google Search is used to promote the company's own advertising business and shopping services. How does this work? Well, AdSense and Google Shopping have received preferential treatment in search results and rankings. And as a consequence, more users have been steered to Google's own advertising and shopping sites, thereby creating an unfair and illegal advantage over competitors. The Commission reached a decision in the Google Shopping Service probe in 2017, and Google was fined almost $3 billion for breaching European antitrust laws, in particular for abusing its dominant market position in the search engine market. 2 years later, in 2019, the Commission closed the AdSense probe, and Google was fined yet another almost $2 billion for antitrust violations in the online advertising market. Overall, the fines against Google total almost $10 billion US dollars. Beside the Google probes, the European Union has also filed a lawsuit against Amazon just a few weeks ago. The company is accused of unfairly using its market position and power to box out smaller competitors and to use data from sellers who use Amazon's marketplace to support popular products, then copy and sell them, often at a lower price. Lastly, Google and Apple might also face charges regarding the alleged unfair terms and conditions in Google Play and the App Store, which allegedly harm and discriminate against certain app developers. The currently practiced European competition policy, same as the latest developments here in the US, are a very important first step in the right direction, one that could help to stop or at least slow down the current trend towards the monopolization of the tech economy. Yet, they neglect key ordoliberal principles. To fully implement the ordoliberal agenda, the following 4 aspects are crucial. First, competition law. The overall goal is to ensure free and open markets with low market entry and exit barriers and healthy competition. To do so, antitrust and cartel laws need to be revised and updated and properly enforced. Critical in this regard is the constant and ongoing monitoring of the development of market structures, for instance, with the help of properly funded and staffed cartel offices, mergers and acquisitions commissions, and other ordoliberal-inspired government agencies, such as trade and communications commissions. Second, merger control and review. M&As should be reviewed in an open, transparent, and democratic manner. This includes public access to the respective documents, as well as public hearings. In case mergers and acquisitions undermine competition, they should be blocked. This is especially the case for so-called giant mergers, such as the one of AT&T and Time Warner. For M&A cases that surpass a certain threshold level, for instance, 5 to 10 billion US dollars, the bars should be set much higher and tougher standards need to be applied. Worth debating is also the proposal of a per se ban on mergers, which reduce the number of companies in a certain market segment to less than 3 or 4 companies. Third, big cases. Antitrust institutions should not shy away from the big cases and superstar firms. They should be willing and adequately prepared to take on those cases and investigate them thoroughly, especially when competition and the openness of markets are at stake. Seen from an ordoliberal perspective, antitrust investigations could, for example, be launched against Amazon, investigating whether the company favors its own more than 100 products over those of third-party sellers, for instance, via better visibility and search rankings, preferential promotion, etc., and whether it forces other companies to use its services. Other investigations could be launched against Apple, investigating the company's strict control over which corporations are listed in the App Store and how. Facebook, investigating the company's dominance in social networking, its acquisitions, and privacy and data breach scandals. And Google, investigating the company's search rankings, dominance in ads, and operating system. Fourth and finally, corporate breakups. As a means of last resort, regulatory agencies should be able and willing to not only block mergers, but also to break up the big corporate players. Both M&A reviews and blocking, as well as potential corporate breakups, could help in preventing the creation of too big to fail and system-relevant companies. In addition, they could also serve as an effective ex-ante deterrent. One way to administer the breakup of companies is by undoing previous acquisitions. For instance, Facebook Inc. could be broken up into Facebook, Instagram, WhatsApp, and so on. Alphabet could be required to sell YouTube and DoubleClick, and Amazon could be forced to spin off its powerful cloud computing business, AWS, and undo its Whole Foods acquisition. Thanks a lot for your attention, and I look forward to your questions and comments.
Thank you, Dr. Woersdoerfer. We do have one question that came in, and it's from Randall Krebs. The first corporation to succeed in creating AI, which can design its next generation of hardware and software, will have a tremendous advantage over its competitors. Will that competition's competitors be reduced to irrelevance? Would you have anything to say about that?
Could you repeat the last part, please?
The last part is, will that corporation's competitors be reduced to irrelevance?
Well, I'm talking here about companies that have a really dominant market share. So as I mentioned before, Google Search, for example, has a global market share of 93%. Imagine we had an insurance company, we had a bank, we had a pharmaceutical company with such a high market share. I'm pretty sure that we would have a lot of discussions about those companies. The problem with monopolies and oligopolies is that the less competition we have, the lower the quality, and especially the lower the degree of innovation will get over time. So there is also no incentive for other innovative companies to enter a certain market threshold. And we might also see higher prices, for example, in terms of advertisement, in terms of marketing, etc. And last but not least, and this is why the European Union has launched its investigation, what Google and those companies have been doing over the last few years is they have promoted their own products and services, which are oftentimes not the superior products, with the help of their own platform. So for example, Google Search is used to promote Google AdSense and Google Shopping services, both of which are services that are not as popular, not as superior in terms of quality compared to its competitor. But because they have such a huge power, such a huge influence in what is referred to as platform capitalism, they are basically abusing the dominant market position to box out competitors.
Great, thank you. And we have one more question from Martha Garcia Murillo. One could argue that these large companies have been quite innovative and provide products for free, quote unquote, to the end consumer. So the question is, wouldn't they be more innovative than, let's say, entry, less resourced competitors?
The problem is that nowadays markets getting more and more, they're closing more and more. So it doesn't really make sense for a social media company to enter the social media market because of Facebook's dominant position. So the problem is that nowadays innovative startups don't really have an incentive to enter certain market segments because they are getting more and more closed. So what I'm talking about is really, what is really important is to have healthy competition, and this requires to have open markets with low entry barriers and low exit barriers, meaning that innovative startup companies should be able to enter certain markets if they choose to do so. But nowadays, it doesn't really make sense from a business perspective for many companies to enter those markets. In terms of that those companies offer free services, well, the thing is that obviously you don't pay for most of the services that Facebook, Google, etc. are offering, at least not in monetary values, but you pay with your personal data and your personal information, which, as I mentioned before, are extremely valuable. And this is the reason why those companies have become so powerful. So we don't pay with dollars or with euros, but we pay with our personal data and information. And when I said that less competition leads to decrease in quality and also decrease in to a lower degree of innovation, what I mean by this is that what we have seen over the last few years is also that we have seen less and less protection in terms of privacy and data protection. And this is where service quality has definitely deteriorated over the last few years.
Wonderful. Thank you very much for those thoughtful and thorough answers. And thanks for your fascinating talk.
Thank you.
We are now going to move on to Leigh Saufley. Dean Saufley is the 8th Dean of Maine Law since its founding in 1962, and the first Dean to report directly to the Chancellor as part of the transition of the law school to a standalone institution within the University of Maine system. Dean Saufley has had a distinguished career of public service. After graduating Phi Beta Kappa from the University of Maine in 1976 and from the University of Maine School of Law in 1980, she practiced in a small law firm in Ellsworth, Maine, worked briefly in the U.S. Veterans Administration Counsel's office, and spent nearly a decade in the office of the Attorney General of Maine, becoming one of Maine's first female deputy attorneys general. Dean Saufley was appointed to the Maine District Court in 1990, to the Maine Superior Court in 1993, and to the Maine Supreme Judicial Court in 1997. When she was appointed by Governor Angus King to serve as Chief Justice of the Maine Supreme Judicial Court in December 2001, she was the first woman to serve in that role and the youngest Chief Justice ever appointed. She served as Maine's Chief Justice for more than 18 years, leaving the bench in April of 2020 to take the position of Dean of Maine Law. Dean Saufley is the winner of numerous awards and honors, including International Women's Forum, Women Who Make a Difference, University of Maine Marianne Hartman Award, Maine Women of Achievement, the L. Kinvin Roth Alumna of the Year from the law school, and the Maine State Bar Association's Caroline Doobie Glassman Award. We are delighted to welcome Dean Saufley.
Thank you, Jessica. Can you hear me? I'm coming through clearly. Had I known that your introduction of me was going to have been that long, I would have issued an order reducing it, but I appreciate your kind thoughts. I am incredibly honored to be here at this Lunch and Learn. And I have to say how proud I am of my alma mater to have put together this extraordinary set of webinars. I've learned more by watching these webinars over the last several months about AI than I knew before I came to this job. So I'm really grateful for the opportunity to be here today. You will find my presentation quite different from anything you've seen, and I will be talking really much more about the law and how it relates to individual lives much closer to home. You've just heard a wonderful presentation on how the law will affect antitrust and anti-monopoly work. I'm going to talk to you, I hope, about some of the ways that the law and artificial intelligence and machine learning come together in individual lives right here in Maine. I want to start my conversation by telling any of the students, scientists, and other professionals who are watching this webinar that now is the perfect time to be thinking about getting a law degree. And although you might expect that from the dean of the law school, I'm actually quite serious about the interplay between law and the technological developments that are changing our world. And here's why it's important for people to think about careers in and around the law. While science, including all of the engineering, computing, and data sciences, are moving rapidly ahead, as you have heard, and the advancements in AI are really increasing exponentially, the law changes much more deliberately. And the practice of law needs lawyers and professionals who understand AI. The legal profession is not known for being nimble, and there's a good reason for that. For a society and its institutions to stay healthy and to be able to progress, the law, writ large, needs to be stable and predictable. Much of the law is built on precedent, historical decisions, descriptors of legal tenets, and much of the law comes from governing bodies such as legislatures and rulemakers. When an idea for a new law is advocated, it must await judicial pronouncements, and it is preceded by substantial input from advocates and parties. And in the legislative and congressional arena, the changes in law must await input from various interest groups who have a chance to weigh in. That process is really a stark contrast to the development of scientific progress, including artificial intelligence. So the speed of science is much more rapid than the speed of law, and yet the law has to be ready to transition as the sciences change our lives. So because the very purpose of the rule of law is to guide human endeavors, and because artificial intelligence is now understood as having an impact on almost every aspect of human endeavors, the law is catching up now and needs to do more so and more rapidly. So people with a background in artificial intelligence will regularly be sought out to help lawyers and judges and legislators understand the complexity of the AI that is going to be at issue. And if you combine a background in AI with a law degree, you will find many opportunities await you. So let me move now to a discussion about the transition in the law, both in practice and in substance. And because I am law trained, not technology trained, I am not always good at sharing my screen. Let me see if I can do that right now. As you have learned, as we have gone through this webinar series, artificial intelligence and machine learning are having an impact on every aspect of modern life. Just a few of the key areas where we are beginning to see serious litigation include the production of food, medicine, healthcare, transportation. As we've heard, autonomous vehicles are going to change our world, communications, information, which is an enormous area of artificial intelligence and data gathering, all of the comforts of home, which we now think of as absolutely necessary to our existence, but the Internet of Things is changing the way we will live in the future. And all of the intellectual property and asset protection issues that are affected by AI are going to require good lawyers and good contracts. And of course, as you've seen, individual privacy is something that we worry about all the time. So as the law is in transition, I'm going to talk to you just very briefly about changes in the practice of law, and then we'll talk about changes in the substance of law. Lawyers themselves are having to learn, as you've watched me struggle with the technology, having to learn how to make technology and AI work better for all of us. And the very first area where we began to see the benefits of artificial intelligence came in the area of legal research. As I began in my work as a lawyer, I would spend hours in the library, laying book upon book, making highlights, scribbling notes from various cases. Then I would go in search of the new case law that I would find along the way. Today, legal research is almost entirely done online, and it is done with a variety of search engines, all of which have benefited dramatically from AI, so that your searches can be broadened and narrowed and made very specific very quickly. It's been an enormous benefit to the practice of law, and it has changed buildings, it has changed libraries, it has had a significant effect on what it is a lawyer needs to be able to do in order to best represent his or her client. The other change in the practice of law that is now beginning to be seen is an assessment of probabilities. If you walk into a lawyer's office with a claim against another person or a business, and you say to the lawyer, how much will it cost me to assert my claim? And how much will I win if I assert my claim? The lawyer can now do a probability assessment that will tell you and the lawyer whether this is a pursuit that is economically beneficial. Now, there may be many other reasons for filing that suit, but the economics are quickly identifiable through an assessment of probabilities. One area where the practice of law has changed that has surprised me in the way it has been very successful is in mediation. There are a number of new AI products that allow people to come to a dispute together through a digital meeting and use a particular program to find a way to resolve disputes. It's been much more successful than we originally anticipated and is now being incorporated into many areas of practice. The same thing is true for trial demonstratives. You want to show the jury what happened to you, you can do so in digital terms. And if you use many of the products that are available now, you can make the issues come to life in a way that simply sitting and describing the situation did not do before. Client communications have been changed. Lawyers are now able to routinely and automatically be in touch with clients in a way that has been a very positive impact on the entire communications practice. You will soon see courts reaching out to people to remind them about their dates and times the way your dentist office does now. In addition, the marketing of legal services has changed. And oddly enough, judging has changed. In fact, there are programs that will allow you to present your case to an AI judge and learn what the result would be. As a former judge, I'm not sure I approve, but nobody asked me. I'm going to move quickly then to changes in the substantive law. And I will focus a little bit on tort law because personal injury liability is something that you see often in movies. You read about it in some of the fiction of our time. But we're beginning to see how tort law is itself being reshaped by artificial intelligence. So if you think about the areas where injuries to a human being may occur, self-driving vehicles are the ones that are most often thought about, and I'll talk to you about that in just a second. Medical diagnoses are now being affected by AI, robotic surgeries. And if there are errors in those areas, then it is tort law that steps up to help people recover from whatever has occurred. So just a quick overview of what happens in the development of a particular area of law is the entire idea of determining who is the defendant in circumstances where someone has been injured in a car accident. We are all painfully aware of the case where the autonomous car hit and killed a pedestrian. If you think about what has to happen in order to determine whether there is or should be liability, the very first thing that has to be determined is who is the defendant? Who made the mistake? Was it the line worker who didn't put some particular part of the mechanics together correctly? Was it the programmer? Was it the coder? Was it the original designer of this autonomous program? Was there a value judgment in the program that people are unaware of? Those additional components have to be overlaid on the traditional elements of tort law. Then you have to determine what is a breach of duty. Is it inaccurate original data? Is it incomplete data? Are the algorithmic assumptions incorrect? Were value decisions made wrong? Was there, in fact, simply a basic mechanical problem with the car itself? The other area where there is already litigation, we're seeing quite a bit of litigation around privacy law, and we are now looking at the variety of different ways that privacy has been affected by artificial intelligence. It has been affected by the arrival of communication technology before we began to talk about AI. But if you think about the vulnerability of data, your own personal data, whether it is your finances, your medical information, where you are today, where you were yesterday, facial recognition technology, who are your personal contacts, who's in your contacts book, the potential harm from the release of that information really runs the gamut. Identity theft can be just horribly difficult to recover from. Disclosure of negotiations in contracts, having the world understand what your finances truly are may change all of the ability to negotiate. If your medical information is released, there are questions around employment, there's personal embarrassment, there are a whole lot of catastrophes that go with that. When your own life is invaded so that people know, have access to your photographs, to your family information, to very personal information, it can change your life. Liberty interests are now being looked at very closely, and the example coming out of China, where an entire group of people are subject to facial recognition review, and their ability to move freely in the world is affected by cameras that recognize them and tell them they cannot go where they wanted to go. The entire idea of freedom of association being truncated because people can get access to that kind of personal information is really quite frightening. So a few other areas where the law is in transition. I'll start to talk very fast so that we can get to the next panelist. Contracts. There are new AI programs that review routine contracts. They can do it faster and more accurately than most lawyers. That's going to be a game changer. Intellectual property, the complexity of rights and the need for clarity of understandings in intellectual property contracts is going to become, I think, an area of law that has an enormous value to those who are working in intellectual property. And healthcare, we could talk about healthcare for hours, but think about the speed with which vaccines are being produced and the amount of technology that has gone into that work. And so let me move on quickly. This is an area of serious concern, and it must be serious concern to all of us working in and around the area of artificial intelligence. Whenever artificial intelligence is at work, data is in use. And if data is in use, we have to ask the questions to make sure we're not making assumptions that are just flatly wrong. First, we have to know whether the data that is being used is actually accurate. Then we need to make sure that the data is being used correctly, that there's not an assumption about data that is inaccurate. We have to know whether the formula, the algorithm, or the calculations embedded in the machine learning are correctly designed. Are they making inaccurate assumptions? We need to know whether the formula has incorporated unintended or even intended but hidden biases. And we have to know what values, which I think is just incredibly important, are reflected in those formula. So very quickly, for those of us working in the law, there are many aspects of AI and machine learning that are really good news. The advances in medicine and healthcare and the improvements in the quality of life are absolutely critical. The same thing is true in the quality of buildings to assure that they are solid, that they're earthquake proof. The entertainment explosion, I don't need to talk to you about all the wonderful things that are coming in entertainment, some of them not so wonderful. The reduction in human error, which is a benefit in every area of science and law. The speed of transactions, you can now have, we are much less patient as a society because we expect things to happen very quickly. And just plainly reducing human risk. Some of the various robotics that take humans out of areas of danger are all improving life. However, one of the things that we have to be careful about as we go through all of this are the flip sides of each of those benefits. So loss of privacy and anonymity is something we struggle with all the time. Autonomous weaponry is just a very, it's a scary thought. People may lose access to employment because repetitive work can be taken over by robots. The decisions that are made and buried and embedded in AI may in fact be subject to unidentified biases. And the decision maker may be very distanced from us in ways we haven't thought about before. And we've got to learn how to incorporate ethics and our own values in AI. So I leave you with a question. Is Elon Musk right? AI, he said, is a fundamental risk to the existence of human civilization. Thank you very much.
Thank you, Dean Saufley. That was wonderful. I'd like to introduce our next speaker, Jim Isaak, current chair of the IEEE USA Committee on Communications Policy and a participant in the IEEE USA AI Policy and IEEE Standards Development on related ethics issues. Jim is President Emeritus of the IEEE Computer Society, past VP of the IEEE Society on Social Implications of Technology, and a past member of the IEEE Board of Directors. He's retired from the computer industry and academia, and you can visit his website at www.jimisaak.com. Welcome.
Thank you. Let's go quickly to the screen share so that we can hop into this, but I'll answer the Dean's question. Elon Musk is right, and we should be concerned. So having started out with that small observation, I'd welcome you all to 1984. That is the price for your personal privacy now, because corporations now have a huge amount of insight about everything you do and what you're doing in real time. We had it, yes, there we go. Stop that computer. You've seen all that or heard all that in the intro, so I will just leave that in case you want to chase those things down. Copies of this slide set will be available, I believe. My main observation here is that AI is becoming pervasive, invasive, and persuasive. That last word is a very important one in this case. You have to realize the large corporations that were described in the first presentation got there by advertising. They were giving away free services and then turned that into revenue by selling access to people. That's you and me. That's a very interesting concept. To accomplish it, you need to understand, ideally, every individual in great detail, and that is now possible. You need to be able to target things to those individuals in terms of messages, and that's now possible. And you need to do that in a way that maximizes the success of those messages, and that's now possible. We can track that in real time. The movie I reference here on Netflix, The Social Dilemma, does a delightful job of demonstrating that whole concept using humanoid characters to represent the AIs as they do these processes of identifying individuals, what ad to present to them next, why they think that ad will work, and so forth. What wasn't possible a decade ago is the ability to do this for billions of people. And now it is possible. We have big data, we have cloud computing, we have very high performance computing, a whole variety of technologies that allow us to do things that weren't possible or even conceivable 20 years ago. AI is a black box. Unfortunately, the dean suggested that we needed a whole bunch of information about the nature of algorithms. Sorry, folks, not available. It goes into the black box makes determinations through machine learning in deep learning activities. And when you present that back to any human outside of the black box, it's going to be a matrix of numbers. And the ability to actually interpret that matrix of numbers and whether it includes biases or unethical content or something else is virtually impossible. I can't imagine exactly how it would be done. And of course, AIs are not conscious. They can't explain how they have come to those conclusions. And to add insult to injury here, the United States has decided not to license software engineers. So it is now not possible to actually get a licensed software engineer in the US who can at least be held responsible the way other engineers would be for similar problems. So every mark, that is every one of us, individuals in the billions of individuals that are being maintained online by this, have a bunch of information about them. Some of it's obvious, your race, your gender, you can imagine how much of this might be easily determined by looking perhaps at pictures or other information you've already put online willingly. Other information is inferred. That is, it is now possible to take a look at your pictures online and make a good determination of what your personality profile is, or your gender preference. And I'll just point out that in some countries, it is a capital penalty, capital punishment is available for people whose gender preferences are not in line with that country's moral standards. And the fact that these algorithms may only be 85% accurate won't prevent those countries from, what shall I say, executing their laws. And the information that is being put into these systems for advertising is available for sale to any buyer. So the IRA, the Russian agency that's been manipulating elections and throwing gas on every fire they could find in the world, is one of the potential buyers, in fact, demonstrated buyer, political campaigns, ISIS, and others. Part of the problem is that advertising is most effective, or getting your attention, which is of course the prerequisite for advertising, is most effective if you have fear and outrage. If those are your responses to what you see, then you're much more likely to view the content, you're much more likely to share the content. Snell Arrow at MIT has done a fantastic book called The Hype Machine, where he discusses this. His group demonstrated over the last 20 years in great detail in scientifically accurate ways that lies travel faster, farther, deeper, and broader than truth does. So who might you target? Well, you might target disgruntled conservative voters in swing states, disassociated persons of color in swing states, who might vote and try and discourage them from voting. Those are two specific targets that Cambridge Analytica used in 2016. You might target teenage girls about to run away from home, or alienated sociopaths who have recently posted violent rhetoric and have purchased assault weapons. And why might you contact those people? Well, you might have very altruistic intent, or you may have very problematic intent in any of those cases. And here's the problem. Artificial intelligence, the processes that now can beat us at chess, now can beat us at Go, are now being applied to maximizing the number of targets, the analysis of every target, that is, say, person on the internet, the ability to understand what they are going to respond to, delivering content to each target specifically across multiple channels. Don't be surprised if you don't see that your most recent web search shows up on your car's GPS system. If you happen to look for a restaurant, maybe a competitor will show up on your GPS system with the same characteristics as the restaurant you searched for. These technologies are going to span and are starting to span these various platforms. And of course, you'll be real-time monitored to determine what the impact of that advertising will be. And if it wasn't successful, the next ad, literally seconds later or milliseconds later, is going to be one designed to be more effective than the last. The liberal Western assumption that white hat memes will win or that we are rational decision makers don't seem to follow. Again, I'll point you to a documentary series, Hacking Your Mind, on PBS that just came out in September. Well worth watching to get understanding of the issues there. So here's the question. Is it possible to fool a sufficient number of people, a sufficient number of the time, to abuse Abraham Lincoln's assertion? Or can artificial intelligences sufficiently influence what we do to affect human agency? Certainly that is the financial incentive of companies like Google and Facebook and others who have an advertising-driven business model, and their success is an indication that there is a level of success already in influencing our decision-making, and that if it becomes optimized the way the ability to beat us at chess does, should be a matter of concern. So what do we do? The Social Dilemma movie I referred to on Netflix discusses this with a number of high-tech talking heads who have been involved in the industry, and they recommend various forms of regulation or intervention by government. It's not clear that antitrust is a sufficient, it looks like a hammer, and as a tool, these aren't necessarily nails. So we need to figure out what type of regulation might be appropriate, if any. The other thing is on human behavior. When you see something that triggers these kind of responses, the first thing to do is stop, slow down, switch out of your reptilian mind to your reflective decision-making mind and think about what you're seeing. Second, investigate what that source is. Is it credible? Do you understand what you're seeing? Next, find alternative sources for that. And then finally, trace any claims and validate references. This is pretty good advice. I'll just point out that with fake video technology available, it's going to be very hard to get people to take these kind of steps when they see something that just is so obviously wrong on video that they have to share it, and it outrages people and can lead to violence, as it has in other countries, maybe even in this country. I mentioned that antitrust is not a well-focused tool. The recommendations out of the hype machine include portability of data so that competition is possible, better privacy laws, have corporations make a commitment to make sure that the data they are collecting and maintaining on people is accurate and representative and reflects good scientific analysis in terms of what can be done. Some suggestions I have that actually came up from reading materials in the last week or so is Facebook would filter nice messages and let you block not nice messages. And those kind of characteristics are things that the MIT group has been doing in terms of analyzing the nature of your posts. Then they would help potentially dampen down the feedback loops that create very strong problems in terms of the divisiveness in this country and potential implications for violence and other things. Another possibility is to nudge users, again referencing the book by that same name, by having the nice filter turned on automatically and let people opt out if they choose. Another one is to require or add citations. So when there's some content being posted that appears to be referencing some external source, either require that to be included or add it. Again, AIs can do the analysis here, identify where sources are, and they might be able to determine that this is apparently inaccurate and here's a citation to more accurate information. So here's a set of resources I would recommend for people's attention and consideration. And maybe we'll have 2 minutes for questions. I'm not sure, but I'll leave this up until our host decides it's inappropriate. All these things are available off my website that was mentioned earlier, and will be, of course, available when this comes online. So probably scared some people. If not, you weren't listening.
Nope. There are a number of questions, but as we are at time, I think what we're going to do is forward these to the appropriate panelists. We're going to forward these to the appropriate panelists, and hopefully you all will have a chance to respond to our questioners via email. I'd like to thank our panelists, Dr. Manuel Woersdoerfer, Dean Leigh Saufley, and Mr. Jim Isaak for being here today for this panel, and thank all of our participants and all of the wonderful questions that we've received. Thank you everyone very much for being here.